Stop! Who are you? What are you doing here? Sorry about that, guys, and just a note. This is not legal advice. It's simply a question about a Senate bill recently introduced here in Kentucky in January of 2020. And a quick caveat here. I respect authority. I'm not some crazy sovereign citizen, but I am a realist. And that being said, until recently, I believed most Americans understood capitalism. Today, I'm not so sure. But I am sure that even fewer have heard of or understand mercantilism. Suffice it to say that King George's policy of mercantilism was the impetus for James Otis Jr.'s tirade against the Crown and its writs of assistance, and one of the sparks of the American Revolution, the United States Constitution, and ultimately our Fourth Amendment. Today, meaning the 21st century, a writ is just a formal order, generally issued by a court. But before there was a United States, a writ was basically any written order given by any noble person or a soldier to take a specific action. Although there are few remaining writs in the United States, such actions are more commonly the result of a warrant or a subpoena. Quite simply, in the original 13 colonies, a writ of assistance could and did authorize any British authority, soldier, etc., to enter upon any property, into any home or business, search any person, their papers, or belongings, absent of any reason, none. No notice was necessary, no probable cause, no suspicion, nothing was required. Just a writ of assistance. The writ of assistance, it was a great tool for the king and his troops in the colonies, but not so much for the pawns and the serfs or royal subjects, or unroyal subjects, or free men for that matter. And by the way, although no one today remembers Mr. Otis outside of a few history nerds, etc., James Otis was one of the first voices for blacks at that time. There were no African Americans. For their rights to own property, enjoy the freedoms of life, and liberty. There's that word, liberty. Liberty. It's the state of being free within a society from oppressive restrictions imposed by authority on one's way of life, behavior, or political views. Whenever a prisoner is locked up, held captive, or confined, otherwise restrained, they have lost their liberty. Another way to state this or put it is that freedom to live as I want, go where I want, when I want, free from control, is liberty. I wonder if most Americans today truly understand this. And why do I ask that question? Consider Kentucky, my beautiful home state, where we just had a regime change and our 63rd governor was installed or sworn in December the 10th of 2019. And here on January 14th, 2020, barely 1 month into the new regime's rule, Senator Stephen Meredith, supposedly a Republican, proposed a bill, Senate Bill 89, that reads as follows. A new section of KRS Chapter 431 is created to read as follows. 1. Any peace officer may stop any person in a public place whom the officer encounters under circumstances which reasonably indicate that the person has committed, is committing, or is about to commit a crime, and the officer may demand 1. The person's name, address, and date of birth, or the person's government-issued identification if in the person's possession, and B. An explanation for the person's actions. Let's examine line 5 just a little more closely. Any peace officer may stop any person in a public place. While this does not specify a sworn public peace officer, but KRS defines peace officer broadly, from commercial vehicle enforcement officers to the jailer or a coroner, or, in some cases, perhaps a security guard. So imagine that it's 2 a.m. or even 2 p.m. and you get off of work, and it's a beautiful day, so you go for a walk in your subdivision. A deputy coroner with an overactive imagination or a grudge thinks you are suspicious and demands your identification, or as it used to be called, your papers. This is nostalgic, all the way back to the 1930s and Germany. It would be one thing if there were a peeping Tom discovered on another neighbor's property spying, but to be on the sidewalk or even in the street or to be stopped for walking, that's another thing. Believe me, we have vandals and thieves in our subdivision, and I would love to catch these guys. But at what price? The cost of our aggregate liberties and freedoms? That's a dangerous slope, my friends. Let's continue. Whom the officer encounters under circumstances which reasonably indicate that the person has committed, is committing, or is about to commit a crime. This part is scary, or it should be. Notice the term reasonably. Contrast this with probable cause. In most states, the difference is that a reasonable suspicion is interpreted more as a guess or a hunch, usually without a fact, but based upon an interpretation of a circumstance, while a probable cause is supported by fact and circumstances, which results in a logical belief. These terms are so important that the Supreme Court in the United States has set standards for it. But let's stop here for a moment. It's an important note to make that, for example, if a police officer has probable cause that you have just committed or are in the act of committing a crime, he or she has the right to arrest you instantly without a warrant, or you handing over your papers or identifying yourself. So, if that's the case, why is this law necessary? I ask you, do we really need to submit to a draconian and fascist society? Currently, our laws protect us from this abuse of authority or overreach under the color of law. Let's look at the difference. Probable cause is important here. Again, it's 2 a.m., or maybe even 2 p.m., and you leave your favorite watering hole. You slowly stagger a little to work your way to your vehicle through the parking lot. You find your car, you get in, rev it up a little, and pull out cautiously, or even maybe a little erratically. Leaving the parking lot, you barely cross over the dividing line, all the while being observed by one of the city's finest. The officer has been trained on the effects of alcohol, and with his experience, he can make a reasonable judgment or have a reasonable suspicion that you're as drunk as Pelosi at an impeachment party. The officer has every right to make a traffic stop. But the officer cannot search your vehicle or even arrest you yet until you either provide consent for the search or the officer has demonstrated that there is probable cause that a crime has been committed or is being committed. No, these actions alone are not a valid basis for either an arrest or a search. However, with reasonable suspicion, the officer flashes his blue lights to pull you over and you comply. He walks up to your window, smells alcohol, and notices that you are uncoordinated and slurring your words. A reasonable person would assume you are drunk. The officer now has probable cause. This is the reason that an officer will interact with you and question you for several minutes before asking you to take a field sobriety test. If the world were perfect and all Leos, law enforcement officers, were as pure as the driven snow, this would not be a problem. However, let's continue. The officer may demand A. 1. The person's name, address, and date of birth, or 2. The person's government-issued identification, if it is in the person's possession, and B. An explanation for that person's actions.
Is this man doing here?
Understand that the peace officer or security guard per KRS 61.900 may demand, "Who are you and where have you been?" An explanation for your actions that is satisfactory. I'm going home? Which could turn into, "Where do you live? Why are you going this route? Why are you here?" This is not 1478. The Spanish Inquisitions are long over, just like the Kavanaugh hearings. You're just an average Joe walking home from your girlfriend's house at whatever time of day or night. Really, do we want to live in a police state where any peace officer can stop you at any time with their version of a reasonable cause and demand, "Who are you and where have you been?" and then ask for your papers and a reasonable explanation? Remember, the Fourth Amendment was added to our Constitution in 1791 to prevent this very intrusion upon our liberty as free men. But it gets worse. Section 2. Any person stopped under subsection 1 of this section who fails to identify himself or herself or explain the person's actions to the satisfaction of the officer may be detained and further questioned and investigated by the peace officer for a period not to exceed 2 hours. Have we already forgotten our rights and responsibilities as free men? If you fail to identify yourself adequately, you don't have your ID because you are jogging, or you are unable to satisfactorily explain your actions, you may be detained. Detained? How? And then where? And then further questioned? Thank God waterboarding is reserved for special cases. And investigated. What does that mean, investigated? Take a DNA sample? Stool sample? Searched? Strip searched? Thank God it's only 2 hours. 2 hours of your life, your security, your liberty, your freedom. And after all, it's such a small price to pay. The Fourth Amendment protects your rights against unreasonable search and seizure. And a thing is searched when there is trespass to your person, your house, or buildings, your papers, your cell phone, or other property and effects. Let's discuss seizure. Property or things are seized when the government or authority takes it from you. People or you are seized when, in this case, a peace officer through force or through expression of authority, you submit to his control. Generally, a warrant is required for either a search or a seizure, but there are exceptions. Usually, a judge must issue a warrant based on probable cause, and even then, the judge who issues the warrant cannot be a part of or have any interest in the investigation, either connected to it in any way which could lead to a question of their judgment. Thus, the reason for a judge to recuse themselves. This bill has no such protections. Only that any peace officer, which may include Joe's friend who can provide a reasonable circumstance, my neighbor saw a blue truck or a white man, can deprive you of your liberty and freedom. Consider also, now that you are being detained for up to 2 hours, you and your articles are in possession. They could potentially be searched for the officer's safety. This is usually applied by what is commonly known as sitla, a search which is incident to a lawful arrest, but that's not addressed here. Presumably, the officer would have the right to be guaranteed safety. Mind-boggling indeed. This is worse than the red flag or the no-fly laws. And finally, after all of this, there is Clause 3. Detention under this section is not an arrest and shall not be recorded as an arrest in any official record. I remember watching the CNN show about a college boy in the car. That was Kavanaugh in the Ford hearing. Yeah. Absolute power corrupts absolute. And the potential for abuse and misuse here in today's electronic age, joined with the propensity of a hostile media to spin an article like an unbalanced washing machine, folks, this is dangerous. Consider, this is not an arrest, and shall not be recorded as an arrest, but rest assured, it will become part of an official record, one which you have no recourse, to prove that there was no crime. The impact to a future job, travel documents such as global entry, a simple stop and interrogation could haunt you for the rest of your life. Citizen, beware. I am curious, what are your thoughts? Submit to authority and control, trade your freedoms for security, or defend your constitutional rights? Leave a comment below. Until next time, take care.